Associate Professor Jamus Lim had made a few observations regarding the bill and statements by various ministers for law in response to questions, and I was one of those at that time, Senior Minister of State for Law, who had addressed a question on the point of Good Samaritan bills. I believe Associate Professor Lim asked why this particular Good Samaritan law is deemed necessary when an analogous law that would do the same for involuntary harm by a helpful bystander would not. And actually, the answer, if you had listened to his speech, is actually answered by Associate Professor Lim himself. He had said this, and I quote, "Granted, the context of those Good Samaritan discussions was distinct and applicable more to the provision of on-site physical or medical assistance to those in need. Importantly, such laws in many other jurisdictions compel aid, whereas the bill in question is essentially voluntary in nature." And that is exactly right. In short, the context of the previous parliamentary questions and the replies to them is different. The previous questions, or PQs, refer to Good Samaritan laws in the context of rendering medical or emergency assistance to people who are ill or injured. For example, in his reply, Professor Jayakumar explained that Good Samaritan laws adopted in other countries broadly take two forms. First, to reduce bystanders' hesitation to render assistance because of significant liability concerns. In these jurisdictions, there are laws granting persons who offer aid in emergency situations certain protections from legal liability. And second, to impose a positive legal requirement on people to assist others in distress unless it will put themselves in danger. On the first point, that is, to overcome bystanders' hesitation, the various ministers for law explained in their replies that in Singapore, we have not encountered reluctance on the part of our citizens to step forward to help in those emergency situations. And on the second point, Professor Jayakumar said that helpful bystanders do not face any major liability concerns in Singapore. For civil liability, a person who offers assistance need only comply with what is expected of a person of his or her skills or experience, so an untrained person would not be held to the standard of a doctor, for example. As for criminal liability, that is generally premised on an intent to cause harm or injury. A person who has acted reasonably and in good faith is unlikely to be held criminally liable. As such, in the context of rendering emergency assistance, it is MinLaw's assessment that there's no need to introduce a Good Samaritan law, though MinLaw said that it would continue to study the experience of other jurisdictions and would review our position if the need arises. The context of the current Good Samaritan bill is different. First, it deals with food donations, not emergency medical services. The considerations are different. And second, as I understand it, Mr. Ng is moving the bill because potential donors are hesitant to donate because of potential liability concerns. And this is different from the emergency scenarios addressed by the ministers for law, where they had not encountered reluctance to step forward and there are no major liability concerns.